Well, hello and welcome to this Legal Futures webinar entitled Corporate Law Update. My name, as you can see, is Keith Markham, and I'll be delivering this particular session for you today. As always, let's begin by having a look at the agenda for this course. I'll just give you a bit of an introduction in terms of the sorts of topics and that we're going to cover during the course of this session. So we'll begin by talking about notice provisions, which are a perennial favourite with regard to this topic. There's always a dispute, and in fact, in our case today, at least two disputes with regard to the validity of notice that's been given. Will there be a genuine breach of warranty claim, or indeed, can somebody rely on an indemnity? And we'll look at examples of both of those in terms of the level of detail that needs to be provided and the timing of that detail being provided, and so on. So that perennial favourite we'll begin with. We'll then go on to talk about indemnity provisions, and particularly issues to do with interpretation of those provisions, and also the interaction between those sorts of provisions and exclusion provisions that may well be found in a share purchase agreement. So some really very interesting cases with regard to indemnities. We'll then go on to talk about material adverse event, and here, ladies and gentlemen, for the first time, COVID-19 rears its ugly head in the context of these sorts of transactions. We will see an enormous transaction worth around about $1 billion US, which one of the parties is trying to wriggle out of on the basis of COVID, and the other party is obviously trying to object to that and ensure that the transaction goes ahead. And we'll see how that's been interpreted, the particular clauses itself that revolve around that idea of the material adverse event, and see where we are with that at the moment. And then finally, for a little bit of light-hearted relief, we'll talk briefly about implied terms. So we'll see a particular case where a party was requesting an implied term from the court about disclosure of certain reports prepared post-completion, and we'll see what the court had to say to that. And finally, we'll look at another perennial favourite on many of my courses, but in a particular corporate context today, in a shareholders agreement, where effectively we've got somebody being removed under bad leaver provisions and also being terminated in terms of their employment as a director. And the question there is, has that particular activity, have those actions complied with an express duty of good faith that is found in a particular clause of the shareholders agreement? So